There's a big difference between being held to answer and trial.
There's a huge difference between being held to answer, which is probable cause of reasonable suspicion that a murder was perpetrated, and I think Judge Clay was very, very eloquent today. The attorneys would be well served to go back and to read the transcript of his holding order, because he synthesized, he distilled the facts of this case, and he raised questions that the defense is going to have to answer in this case, and the district attorney.
What sort of job do you think the defense did on this? I mean, there was the risk of putting all their witnesses out there, and he addressed that today, too.
Both the district attorney and the defense attorney did a wonderful job in both of their positions, in prosecuting and in defending. Now, you can talk to a lot of different attorneys, and they will tell you they would have defended this case differently. Personally, I wouldn't have put all those witnesses on because they're locked in now. I'm sort of a simple guy. If, in fact, he thought he was going for a gun, then that's, in fact, what the defense should be. I think a jury might be sympathetic to that. He's in a very volatile situation. He sees a man on the ground that he perceives to be resisting. At least that's what they're implying, the defense is. That might sell to some jurors, but when you throw in the taser and say later, oh, I thought I was going for my taser, a jury is going to ask, okay, which is it? Were you going for the gun? Did you think he was resisting? Or were you going for the taser? In other words, which time were you telling the truth?
You said before that you've seen manslaughter, that you don't, you said before that you see it more as manslaughter from what you've seen as evidence. You heard the judge lay out murder, intent. Do you agree with what the judge said?
Well, it's interesting. This case, as I've said right from the get-go, will come down to what do the jurors bring to the jury room? What is their state of mind? Because you can look at the tapes in this case, and you really can come to any conclusion that you want to, and that depends on your bent. As we sat in there today, you could hear the mumblings of the Mehserly family, and I can almost hear them thinking they're not getting a fair shake here in Oakland. They're not getting a fair shake in Alameda County. But yet, throughout this preliminary hearing, Oscar Grant's family wasn't happy at times. A lot of attorneys would say, well, that sort of balances out. But what the judge did with the burden of proof was the right thing. The facts that he had, he held him to answer, as I said right from the beginning, for the murder.
And the judge... Do you think that Mehserly is going to have to testify? The judge says, I don't know his state of mind, bottom line.
I have said that again right from the get-go. There is no way a jury will find Mehserly either not guilty or guilty of a lesser degree unless he testifies in this trial. Because you can't put on other witnesses to talk about what's in Mehserly's mind. He is going to have to get on that witness stand. What I don't like about the defense in this case so far is just the approach. They've locked themselves into a defense now. It's the, oh, I thought he was resisting, and I thought I was going for my taser, when he never mentioned the taser at any time after. It's going to be an interesting case, and that's why I say, to my mind, they would have been better off not putting all these witnesses on, not putting the police officers on to, in my opinion, exaggerate, exacerbate their view of what was going on that platform. They are now locked into their defense.
Can they refine that defense a little bit, going into the trial to eliminate one of those two factors, the taser or the going for a gun?
I'll tell you what, Judge Clay in this case said that for him it really wasn't in the videotape. For him, it's what was Officer Mehserly's state of mind. I couldn't agree with him more on Mehserly's state of mind. That is of paramount importance. But also, that tape shows actually what went on. It's not open to interpretation. It's not often open to witnesses wordsmithing what happened. They will put the tape on, but more importantly, they will have to put Officer Mehserly on that stand. And I am telling you, he will have to get on that stand, and he will have to show remorse. He will have to apologize, and then explain what exactly was going through his mind at that time. And again, that's why I look at this, knowing the burden of proof having done defense work for an awfully long time, having been an attorney for over 30 years, I don't understand why they put so many witnesses on. It just locked them too much into a story.
And what sort of shot do they have of getting it moved out of Alameda County?
I don't think a very good shot, because this is an awfully big county. You've got North County, we go all the way out to Livermore. There will be enough people in this county who will get up and say, I really don't know a lot about it. Keep in mind, jurors can get on the stand and say, I've read about this trial, I know about this trial, but I haven't made up my mind yet. Let me hear the evidence. And that person will be a good juror for this case. When I prosecuted in this county and when I defended this county, I never ceased to be amazed in big cases where a lot of jurors get up and go, I know a little bit about this case, but not too much. So I think you're going to find a jury in this county, and when they make their motion for change of venue, that will be soon, I would think. I think it will be denied. But it can be reinstituted when you are picking the jury. If jurors get up there and say one after the other, I know about it, I made up my mind, I can't be fair. But I don't think that's going to happen. This case will be tried in Alameda County, in my opinion.
What did you think of that last witness? I mean, here his good friend spent 6 hours with him in days, in the days after, many hours.
You know, my heart went out to him just as he was walking out to the stand. I thought, oh my God, what an awful position that he is in. Here, a friend of his is accused of murdering someone, and he is asked to testify against him. But I was impressed with his testimony because he clearly told what he perceived as the truth. And that was that Mehserly did not tell him that he was going for a taser at any time. But what I didn't like about that was this was at a preliminary hearing. It could be cross-examined more deeply, where you ask, did you give him an opportunity to do that? Were you really talking about the entire incident? So I don't think we've heard everything that officer can say about this, but I think it will ring loudly with the jurors when they hear he didn't mention a taser.
Do you see any potential here that some of the officers who testified could be perhaps tried or perjury, or
No.
that Bart, or for the assaults or anything else? Do you see anything else coming out?
Absolutely not, because what the officers did was they testified to their perception as to what was going on that BART platform.